yazi ukuthi amaciko ahlukene phakathi kukhona abaculi, kukhona ababhala izingoma, kukhona ababhala incwadi lezi esifundayo, kube khona abantu abakwazi ukuthi bekudwebe, bekupainte, benza lokho esithi ama sculptures ne-painting. Labo bantu batholakala kwi-art gallery. Hlukene amaciko ewodwa. Ingakho bekubalekile ukuthi contractual terms that has led to creators signing away their rights. Iyayichaza ke lo mthetho ukuthi isikhathi esiningi bese sibone ngesikhathi esingaphambili abaculi isikhathi esiningi njengoba esecazile usihlalo ukuthi sinabaculi esibaziyo esibahloniphayo bacula isikhathi eside, kodwa abanye baze bashiye emhlabeni bengakwazanga ukuthi imisebenzi yabo ikwazi ukuthi bakhokhele ngokulinganayo nemisebenzi kade beyenza. Usihlalo ukwenza umzekelo ngoMahlathini, abaculi ingqalabutho esiqhenyayo ngazo uthola ukuthi bayacula kodwa abakwazi ukuthi baqonyeliswe njengacula abakwazi ukuthi bawarecord. Baningi ke amaciko anjalo. So lo mthetho uzozama ukuthi uvikele abantu lawo ma-right ukuthi ezinye zezinto abayiphakamisayo ukuthi uma kusayinwa inkontileka lokho esithi ama-contracts, isikhathi esiningi abanye bebengatholanga ithuba lokuthi beye esikoleni beyofunda. So umuntu bejatshulisa ukuthi uyorekhoda nje, uthola ukuthi uyasayina, usesayina away namalungelo akhe. Ekugcineni mesenikwa imali encane esekhala bese kudonswa i-contract etshengisa ukuthi nawo ama-terms and conditions akhona kule kontileka yakho, wena sikukhokhela ngokwe-contracts. Ngokomthetho awukwazi ukuthi uchallenge into ebhaliwe ngoba kuvele kudonswa i-contract kube ukuthi it's binding because usuyisayinile. So kuyaphakanyiswa ke la ukuthi kunegaba ekufanele ukuthi zifakwe kulezi inkontileka ukwenza isiqiniseko ukuthi nawo amaciko ethu ayavikeleka ukuze engasayineki inkontileka ezobalambisa bezobakhokhela imali encane. Ezinye zezinto, other objectives of this copyright amendment bill is to introduce what we call a resale royalty right. This resale royalty right means that an artist will be entitled to a royalty when their original work is resold commercially. Njoba sengishilo ukuthi ke i-resale royalty right izohlomulisa ama-artist kakhulukazi abaculi. Uthola ukuthi umculo wakho uyadlalwa, udlalwa e-station, udlala emaklabhini, udlala ema-restaurant, udlala emsakazweni, kodwa yena ngokuthi mhlawumbe wasayina i-contract eyenza ukuthi imali eningi ye-producer noma ku-composer, uthola ukuthi akasayithola imali. So le mthetho kuzophakamisa ukuthi kufanele ukuthi amaciko umnikazi womsebenzi okuyena umuntu esingasho ukuthi it's a corporate right owner, okuyena oyiciko kufanele avikeleke. If umsebenzi wakhe usaqhubeka usadayiswa naye phela kufanele athole okungamangqushana lokho esithi ama-royalties. It also introduced a fair use system for the reproduction of copyright material for limited use or purposes without obtaining a permission and without paying a fee or royalties. Furthermore, this provision stipulates that the factor that needs to be considered in determining whether the copyright work is used fairly. The system lena ibalekile in a sense that kubalekile ukuthi siqonde ngoba kumale amaciko ethu kufanele iqonde kahle le system njengoba sengichazile ukuthi iyona system le esiboleke eMelika. Siboleke eMelika, le system izosebenza la eSouth Africa. Ama conditions akhona awafani nawethu. Kakhulu inika amandla kakhulu inkantolo. Lokho sithi ama discretionary powers to determine ukuthi in terms of exception imaphi ama activities azoshiwo kuthiwa ama exception. The system ke fair use ayihambisani yodwa, ihambisana ne fair dealing ekade ikhona-ke la eSouth Africa isikhathi esiningi. I-fair dealing involve a close number of defined exception. There is a close number, at least iyasho i-fair dealing ukuthi ama-exception nanka. If wenze leyo nto kuzokwazi ukuthi kuthiwa ama-exception. Akufani njenge-fair use. I-fair use ingasho ukuthi i-flexible. Ayinayo nje i-list yama-exception. If umuntu engasebenzisa umsebenzi wakho ezumculi uthi uyakuyena ethi umuntu hayi sohlangana enkantolo befika enkantolo ngempela inkantolo ithi owakhe lo msebenzi ngempela kuyoba njalo. So siyabona ukuthi amaciko nge-fair use ingathi awavikelekile kahle kodwa nge-fair dealing amaciko ethu ayakwazi ukuthi ngoba yona singasho ukuthi kaphecelezi i-rigid futhi they are specified listing akhona ngale system, and also to provide for exception and limitation in education and libraries and museum and computer program, to also provide for the availability of accessible format copies of a work to accommodate persons with disability. Ezinye zezinto ezikhona ukuthi kuba khona icase esibuya i-constitutional cause where i-Blind South Africa ithathe ungqongqoshe waka trade industry and competition to court to challenge ukuthi this copyright does not protect abantu which are disabled. So kwafanele ukuthi ke manje njengoba eminye emtheshwana inkantolo ithola ukuthi some of the sections are unconstitutional. Kwafanele ukuthi kubuyelwe emuva ke now to ensure that we amend this section to be in line with a judgment which was taken by the Constitutional Court. In this case, to ensure ukuthi nabo abantu abadisabled bayakwazi ukuthi now babhekelele. And enye yezinto is to provide for the sharing of royalties. Lo mthetho ugqugquzela ukuthi kufanele kube khona ukwabelana ngama royalties in respect of literal, musical, artistic and audiovisual works. Umuntu ke waba nomhlangano namaciko whereby kwavela ukuthi bayakhala society lama collecting management akhala ngokuthi basuke bewathatha kuma licensing fee because bona umsebenzi wawo ukuthi wonke umsebenzi wakho njengomculi kuzo zonke lezi indawo esingasho ukuthi ama user alomsebenzi baba nama license ababa namo bese bekhokha imali ethile. This is what is called licensing fee. Lama collecting society njengoSambu akollethe le mali bese bamba lama administrative fee ushintshiko salayo bese nika amaciko ayakhala ukuthi ke athola imali isincane kakhulu. It provides for the recordal and reporting of certain acts to strengthen the copyright tribunal so that it can deal with all copyright and related rights. Lo mthetho uphasisa ukuthi kube khona what we call uhlaka esilibiza ngokuthi copyright tribunal. Lolu hlaka lolu ethiwe copyright tribunal umsebenzi walo ukuthi lixazulule zonke inkinga ezikhona emanate in line or dispute to try and resolve ama dispute avelayo mekuqhamuka lo mthetho esithi i-Copyright Act. I-tribunal ke la inobani uChief Justice uye ephakamise amajaji amathathu ewakhomba ukuthi azohlala kwi-tribunal. Bayamajaji angasekho active beyayini kodwa ijaji retire as we know in terms of the judge's remuneration ngoba likhokhela noma sehlele. Ijaji retire liyabizwa ngoba liyakhokhela ama benefits remains kuba ijaji uzuyo. So kuba khona amajaji awu5 afakwayo suthi i-tribunal i-copyright le inamajaji awu8. uyakwazi uku-appearisha kuyona informally, uyakwazi uku-appearisha u-represented. Kodwa ama-processes akhona, they are informal as much as possible. Awafani njengenkantolo where processes are adversary. Kodwa ayenza ukuthi nabantu kube lula ukuthi bekwazi ukuthi bebeke inkinga zabo. Ayasiza kakhulu ke kuma dispute abakhona phakathi kwamaciko nawo lease collecting society. Ayasiza futhi ukudecide ukhona ama dispute akhona njengoba ke kube khona ukuthi kuba khona ivumelwano phakathi kweciko osithi order no producer. If kukhona dispute labo bantu baya kwi copyright tribunal. And enye futhi is to address the rights of authors in commission work that include to facilitate commercial exploitation. And also this amendment is to introduce technological protection measures to reduce incidents of copyright infringement. Ukhona ke izinto abazenzayo ukuthi bezame ukuthi njengoba sazi ukuthi there is new technology. We are in the fourth industrial revolution. Kubalekile ukuthi nathi as a country we must align ourselves with the fourth industrial in terms of technology. Now nabo lo mthetho bekufuna ukuthi siuchibiyele ube in line with lezi nguquko. Ngoba sengishilo before ukuthi there are treaties international that inform these bills. The Copyright Amendment Bill, the Performance Protection Amendment Bill. Eyokuqala what we call it's a World International Property Organization Performances and Phonograph Treaty. Yebhadi ke le treaty asiyona ingxenye, we are not a member. But kodwa sesibukele ngoba umthetho wayo uvikela amaciko nayo, ama-performers, nama-actors, nama-singers, nama-musician, no-producer. Sesithathe nakuwona ukuze sikwazi ukuthi nathi sishape imithetho yethu. Enye i-treaty is Beijing Treaty on Audiovisual Performances. This deals with the intellectual property rights of performers in audiovisual performances. This treaty is administered by the World Intellectual Property Organization. South Africa futhi ayiyona ingxenye, ayiyona imember kule Beijing, but kodwa sesithathe nje ngoba sesifuna yonke into esisizayo ukuze sikwazi ukuthi nathi sikwazi ukuthi imithetho yethu ikwazi ukuthi stand the test of time, ibe constitutionally, and also it must be in line with international law. Constitution, there's a section which is compulsory to ensure that whatever law that we pass, it must be in line with the international law. Enye futhi is Marrakesh Treaty to facilitate access to published works for persons who are blind, visually impaired, or otherwise print disabled. This treaty is to facilitate access to publish work for persons who are blind. Le treaty ke le ibhekelele kakhulu abantu abakhubazekile nabantu abadisabled. Kodwa futhi nangeshwa asiyona isignature, asiyona ingxenye yayo asisayina. Kodwa sesibukela ukuthi singakwazi kanjani ukuthi silekelele abafowethu laba abahlala nokukhubazeka. Enye futhi i-convention ke siyingxenye yayo ke lekuthiwa i-Berne Convention. South Africa is a member of Berne Convention. This convention deals with the protection of literal and artistic work. Nayo ke le convention ivikela imisebenzi yamaciko, ivikela namalungelo awo. No ukuthi kufanele ukuthi akwazi ukuthi ahlomule abaculi kakhulu. Imali eningi ingayi kuma collecting society. Now moving forward, izongena kuma proposed amendment in terms of this act ngoba i-copyright copy, I'm sure ikhona i-copy kishiwe. Kodwa sengizongena ngigcile ukuthi clause by clause kodwa ngizothatha lawo ama-clause ambalwa nje ekuyiwona aphakanyiswayo ukuthi azokwazi ukuthi abuyekezwe. U-clause 1-ke ukhuluma nge-definition. Definition section ila khona kuchazwa khona amagama asetshenzisiwe kulo mthetho ochibiyelwayo. Umthethosivivinyo ochibiyelwayo kunamagama asetshenziswayo amanye awo nje i-accessible format copy lawa kakhulu acheme kakhulu nabafethu laba which are disabled. Kube khona definition which deals with art market professionals. Sifuna ukusho lokhu ukuthi ke lo mthetho uyakusho ukuthi lawo phela ama-artists ama-professional. So this copyright amendment acknowledge that, and also kunama definition akhuluma ngo-authorized entity, broadcast, nakaza ukuthi what is collecting society, no company acts, copyright management njalo njalo. Afishane nje i-issue ye broadcast in the copyright is to be aligned to performance protection, more especially because that is where the issue ye broadcasting isebenza khona ngaphansi komthetho lo esithi i-performance protection amendment bill, because lapho imisebenzi isuke sisebenzisa lokho esithi i-wire or wireless system. So that is why khuluma ngendaba ye broadcast. Clause 2 proposed the insertion of section 2 capital letter A in the act, circumscribing the extent of copyright protection. This clause provides that copyright protection subsists in expression and not in ideas, procedure, method of operation, or mathematical concept. Afishane definition this section ikhuluma ngokuthi i-copyright ingene ukwazi ukuyiclaima uyayiregister firstly bese ukwazi ukuthi uvikeleke ngomsebenzi wakho mekwenze njani. Iyachaza ukuthi ayikwazi ukuvikela i-idea nje. Kufanele futhi uyiregister nophiko esithi i-companies intellectual property commission la khona izinto enjengo copyright or trademark or register khona. Ezinye zemthetho ekhona lemisebenzi ekhona ukuthi if unento yakho kufanele ukuthi leyo nto yakho uyiregister ukuze ukwazi ukuthi ube namalungelo ukuthi omunye umuntu engayisebenzisi ukuze ethole imali. Kodwa leyo nto ufuna isetshenziswe wena. Ingakho ngingakubalula ukuthi lo mthetho kuthatha isikhathi. Ngiya-understand because this law or this discipline is highly specialized. Lo mthetho uyinkinga even nakubantu ababameli nabafundile, this intellectual property, because it's a specialization of some kind. Not every lawyer is specializing in intellectual property law. Ingakho ngisho ukuthi maybe kuzothatha isikhathi ukuthi ezinye izinto beyiqonde because it's highly specialized this discipline. And we've got few law firms who practice in this. Kangakanani ke abantu abangafundilanga umthetho. So ingakho zama ukuthi mhlambe singene kwamanye sigcile ukuthi le clause ichaza ukuthini. Clause 3 of the bill proposed an amendment to section 5 of the Act by providing for ownership of copyright made under the direction or control by the state. Now, the ownership of copyright where it belongs to a state, you cannot assign it to another. It is only the state which is entitled to ownership of that right. Clause 4 of the bill proposed an amendment to section 6 of the Act by providing for communication to public of a musical work by wire or wireless means, including interest in making available to the public a work in such a way that members of the public may access such work from a place at a time individually chosen by them. So uclose 4 ke uzozama ukuthi ukwazi ukuthi abantu bekwazi ukuthi bethole nalemsebenzi beyihlalele emakhaya in a form of internet. Clause 5 ukhuluma share in royalties regarding literal or musical work. Clause 5 of the bill proposes ukuthi kufanele kufakwe a new section. Section 6, capital letter A, specifically providing for royalty sharing after assignment of copy in a literal or musical work, or where the author of literal musical work authorizes another to do any of the act contemplated in Section 6. Share of royalties to be determined by written agreement. Into ebalulekile ukuthi ungene kwisivumelwano nomunye umuntu, lapho wena umculi ungena isivumelwano nomuntu, kufanele besivumelwano seni phansi right. Akufanele isivumelwano kubalekile ezinye zezinto eziphakanyiswa clause 5. The royal provisions are similar in the bill. Section 6, capital letter A, Section 7, capital letter A, Section 8, capital letter A, they addressed a historical policy gap of royalty payment. When authors or creators or performers have historically had to have the legislative framework to ensure protection, fair and equitable payment for their work. Lack of royalty payment and abusive conduct phakamisa le section uzama ukuvimba lento ukuthi abantu bengene besayine inkontileka ezibashiya benganamali ngemisebenzi yabo abayiunayo. So ingakho sekuphakanyiswe a standard clauses ekufuneka efakwe kulowo ama contract. Clause 6 of the bill proposed an amendment to Section 7 by providing for distribution of artistic work to the public, communication to the public of an artistic work by wire or wireless, including internet. Sesikushilo ukuthi ila khona umsebenzi uhanjiswa siwuthola noma sihlalele emakhaya ku internet. Clause 7 also talks about the sharing of royalties. La khona share. Clause 7 also inserts Section 7B that provides that the author of a visual artistic work in which copyright subsists or their heir must be paid royalties on the commercial resale within the art market of that work. Yona ke le sikhuluma ngayo ukuthi ke iciko ufuna likwazi ukuthi umsebenzi wawo uma uphinda udayiswa likwazi ukuthi likhokheleke nalo commercially. Royalties in respect of visual artistic work shall be payable at the rate prescribed by the minister after consultation with the minister responsible for arts and culture. Iyasho ukuthi kufanele kube khona ukukhulumisana kwalabo ngqongqoshe to have a prescribed rates ukuthi amaciko azokhokhelwa irate engakanani. Kufanele kuhlangane ngqongqoshe ababili, Minister of Trade, Industry and Competition, no Minister of Arts and Culture. The seller and the art market professional are jointly and severally liable to pay the royalties to the author. It also provides in Section 7C to 7E for authors of visual artistic work to enjoy the inalienable resale royalty rights on the commercial resale of the original work of art, subsequent to the first assignment by the author of such work of art. It includes the resale, duration, assignment, or waiver. La many ngena kulesi sivumelwano sokukwazi ukuthi kube khona ukuthi nibe nesithi amalungelo akho wadlulisela kuloyo mhlawumbe umculi wena angithi ingoma kwesinye isikhathi kuba khona umbhalo wezingoma ama writers laba abayibhalayo nabo ufuna bavikele kube khona ozoyicula a musician kube khona ozoyiproducer uyayizona kube khona ozoyipublisher bonke laba bantu banamalungelo efuna avikeleke lamalungelo abo. Ivumelano esingena kuzona ke silaba abantu kufanele sibhale phansi konke ukuthi lesivumelano sizothatha isikhathi esingakanani, lesi sivumelano sizokhokha kanjani, sizokhokha malini, izinto ezibalekile for a contract to be valid, there must be consensus, there must be meeting of the mind. Kufanele kube khona leso sivumelwano, i-law of contracts isho njalo. These are principles akho ukuthi kufuna ukuthi akwazi ukuthi wenze isivumelwano esi-unlawful. Isivumelwano sakho ufuna wenze isiqiniseko ukuthi kukhona this meeting of the minds, ukuthi lento enivumelane ngayo kuyiyona, hayi lento mhlawumbe wena ucabanga ukuthi iyona. Sidlule lapho sikhulume clause 8 of the bill, which proposed an amendment to section 8 of the Act by providing for distribution of an audiovisual work to the public, authorizing commercial rental of the work to the public, communication to the public of an audiovisual work by wire or wireless. Lapho kumsebenzi usudayiswa khona uthunyelwa ngobuxhakaxhaka lo obuba khona, kuba khona ivumelwano phakathi komuntu owumnikazi womsebenzi nalowo muntu okuyena ozobroadcaster nozokuthumela. Kubalekile ukuthi ufuna kube khona ivumelwano nalabo abazobe berenta nabo, futhi ufuna kucaca ukuthi meberenta ke labo bantu bazokhokha kanjani. Ezinye izinto ezibalekile kakhulu. Clause 11 of the bill proposed the substitution of section 9 capital letter A of the Act. It required the recording and reporting of any act contemplated in section 9C, subsection D, E, or F, and makes the failure to do so an offense. Uma ke kukhona ukuthi ke mhlambe lemithetho ayilandelwa njengoba ibaliwe, konke ke lokho it constitutes an offense. Uma kukhona umthetho ungalandelwa, usuke usuphule umthetho. Konke ke lawo ama-case anjalo ahanjiswa kwi-copyright tribunal. Ekuyona efuna idile nama-copyright infringements. Lamajaji engiwabalile ekuqaleni. Igwebo ongayithola-ke laphana ungathola i-fine noma imprisonment ukuthi uboshwe, not more than 5 years. Or uthola i-fine uboshwe futhi. Ezinye zezinto ezenzakalayo. Section 11A provide for making the work available by wire. Clause 15 of the bill proposed the insertion of section 12A in the Act, providing for the general exception from the copyright protection for all works. Ilakona provide for fair use and fair dealing. Ensure the usage of work is fair. The nature of work, the amount, and the substantiality of the part of work. The clause include example of purposes of using, like for research. Fair use is a doctrine under copyright. For example, Tinala in South Africa is the intellectual property law. Asinayo ibala la uthi sikhuluma ukuthi i-fair use ithathwe kakhulu elukhuzeni e-America. Thina la sisebenzisa i-doctrine i-fair dealings ekuyiyona njengoba singene kulama treaty esingene khona. We don't have a fair use. The fair use is an exception to the exclusive right of copyright owner. Fair exceptions include but are not limited. This is a parrot, comments, news, reporting, teaching. I'm an example, I'm an exception. It allows users to make use of copyright work without permission or payment when the benefits society outweigh the cost to the copyright holders. The interest of a private individual is outweighed by the interest of the society. The introduction of a hybrid introduced DTIC but propose ukuthi kube khona i-hybrid fair use provision in a policy position. It's a policy provision, but they are proposing ukuthi both these fair dealing and fair use as a country we must use them interchangeably. Ilokho abakuphakamisa ukuthi womabili lama principle asiwasebenzisi. ingakho kubalekile ukuthi njengamaciko wenina njengoba ngibona nje kukhona namanye amaciko akhona la inhlangano zawo ekufanele ukuthi nabo benze iphakamiso ukuthi yiphi system abayipreferyayo bese benza iphakamiso ngoba kuzobaleka ukuthi ke kube khona ukuthi nabo benza iphakamiso after sesethulile lemithetho esichibiyelayo emibili. It is according to DTIC, this principle is addressing socio-economic developmental state of South Africa. As we know, in terms of the National Development Plan, we are advancing toward the developmental state. So DTI is leaning toward fair use because they believe that it addresses the socio-economical challenges. The Portfolio Committee on Trade and Industry agreed that the bill should use a hybrid approach to fair dealing, which must be encouraged fair use. A hybrid model is the mixing fair use with pre-existing fair dealing provision creates a hybrid model. Fair use is not foreign to South Africa, and obviously called. Other jurisdictions have introduced it. The provision of fair use have safeguard countries that are applying fair use tend to be more innovative and with a growing creative industry. There are several countries in the world with open broad exceptions and have not been found to be in a contravention of international law. Other countries have adopted fair use, such as the US, fair use, Israel, Sri Lanka. The current system in the Copyright Act of 1978 is fair dealing. Isikhathi esiningi la eSouth Africa besebenzisa fair dealing le esingasho ukuthi i-rigid inesibalo esithile se-list yama-exception ayidingi yona ukuthi kube khona i-discretion yenkantolo. Comprising of a closed list of exceptions, the Act does not define it. For subsection to clause 15, it seeks a balance that ensures reasonable access to users to copyright protected work to ensure access to information, research, education, resources for persons with disability, and other exceptions. The Copyright Amendment Bill aims for a developmental approach for the older copyright owner and users. It addresses issues of public interest, access to information and knowledge, protection in line with international development. The exceptions were found by DTIC to be aligned to international treaties. DTIC as people who are drafting these two bills, they are saying that these two bills are in line or are aligned to international treaties. In line with the three-step test. The three-step test is sebenza kakhulu kwi-fair dealing to determine ukuthi i-matter is an exception or not. User kakhulu three-step test. The current Act has a list of exceptions that are limited in scope. The current parliamentary process tightened and strengthened the exception further. The following amendments were made on the quotation. Name of the order to be mentioned if it appears on the web. Deleted practicable in respect of and include to the extent justified by the purpose and fair practice. It was recommended to use both fair practice and the extent justified by the purpose as the Act. The recommendation lama principles or lama systems fair use the fair dealing asiwasebenzise omabili. Kukhona isiphakamiso esisho njalo ekuzofanele ukuthi amaciko ke bese fika ngakule section abukisise kahle. Nabo bonke abantu aba-affected by these two bills ukuthi babukisise ukuthi bona yiphi system abayipreferyayo. Ba prefer ukuthi hybrid, which is a mixed economic which is a mixed system. Initial focus on reporting current event exception, as far as practicable, recommended to exclude and remove from the bill. Lama section la amanye esibonile sisaqala ukuthi even no president ube na concern amanye awo abesekishwayo. Provide for change the wording to read non-commercial purpose instead, not for commercial purpose. Added language and culture as reason for translation or further use of translation. Fair practice is retained for translation. There were technical amendments and instead to read the provision as all-inclusive. Provide for permission to make transient or accidental copies of work, including performative and integral and essential part of a technical process. Provision was retained as a slight amendment of removing the word independent economic significant to read as commercial significant. Because section 12D provide ama exception ukuthi ama exception ekuyiwona azokwenza ukuthi ungatholwa ukuthi une copyright infringement power statile la under section 12D. Clause 16 of the bill propose an amendment to section 15 of the Act provide for general exception from protection of artistic work and incidental use exception. Freedom of use of public spaces, arts and building without restriction. E.g., Nelson Mandela statute in Parliament, while ensuring the artistic or architect still benefit from copyright rights. South Africa does not have freedom of panorama. A comparison between South Africa, the freedom as a panorama, which is South Africa, I know the freedom a panorama when it comes to 70 abantu. Clause 21 of the bill proposed amendment to section 19B of the Act by providing that the person having a right to use a copy of computer program shall be entitled, without the authorization of the copyright owner, to observe, study, or test the functioning of the program in order to determine the ideas and principles which underline any element of the program. If he or she does so while performing any of the acts of loading, displaying, running, transmitting, or storing the program which he or she is entitled to do. Also, this clause deals with exceptions now regarding computer programs. Here, Kulumang section 19, where there was a case, the department is saying has noted development on the Blunt SA case where matter regarding the constitutionality of the Copyright Act as well as the constitutional judgment. In the court application, the Act was found to be unconstitutional to the extent that it limits or prevents persons with visual and print disability from accessing work under copyright that persons without such disability are able to access. The case ibiphakamisha ukuthi naye umuntu one challenge disability kufanele kwazi uku-accessa this copyright work njenganomuntu onganayo inkinga ye disability. B, it does not include provision designed to ensure that persons with visual and print disability are able to access work under copyright in the manner contemplated by Marrakesh Treaty to facilitate access to published work for persons. Njengoba besishilo ukuthi kunamanye ama-treaty esingayona ingxenye esingayona imember yawo kodwa siyathatha kuwona lawo ma-international treaty njengayo le i-Marrakesh ekuyi-treaty yabantu aba-disabled abane-disability. Siyakwazi kodwa ukuthi siyibuyekeze siyenze into eyishoyo. We also revisit the issue of moral rights. Clause 23 of the Pope, an amendment to section 20 of the Act, thereby providing for an author to have the right to claim authorship of the work. kufanele ukuthi umuntu okuyena umnikazi womsebenzi uyakwazi uclaim umsebenzi wakhe and object to any distortion, mutilation or other modification of work where such action is or will be prejudicial to the honor or reputation of the order. Kufanele ukuthi lo muntu elwisane nokuthi umsebenzi wakhe ushintwe engazi yena or bewenze into engayona i-original work yena abeyenzile. Unalelo lungelo ukuthi elwisane naleyo. Siphinde sikhulume ngente ownership of copyright in commission work. Yenzeka ukuthi ke kube khona ukuthi kube nemsebenzi which is commissioned. Is commissioned lemsebenzi ukuthi yenzeke. Whereby abanikazi bemsebenzi bazothola umuntu ukuthi sicela ukuthi usenzele lo msebenzi. Now, clause 24 of the bill proposes an amendment to section 21 of the act to provide for the ownership of any copyright subsisting in the work between the person commissioning work. Firstly, between the person commissioning work and the order who executed the commission to be governed by a written agreement. Ikuzela khona ukuthi lezi vumelwano eziba khona between umuntu ocommissioner umsebenzi nalo okumnikazi wawo kufanele kube khona isivumelwano esibhalwe phansi. It further provides for the protection of author by allowing an application of the tribunal where the work is not used by the person who commissioned it for the purpose it was commissioned. Where the work is used for the use other than that for which it was commissioned. When the commissioned work is of a personal nature, the tribunal may not license the author to use that work or any into futhi enziwa i-tribunal iyakwazi ukuthi ikhipha ama license ukuthi imsebenzi. When considering the license when the work is not used by a person who commissioned, the tribunal must take all relevant factors into account. The Copyright Act does not define commission work. Commission work is simply a term which is when you request or commission another person or organization to create or produce copyright work for you and paying for it. It applies to a photographer or a painting or drawing, the making of an audiovisual work or sound recording. The issue of assignment of literal or musical work. Clause 25 ukhuluma ngendaba to assign umsebenzi or literal work or musical work. This bill proposed amendments to section 22 of the Act by providing that a copyright owner vesting in or under the custody of the state bese sikshilo ke lokho ukuthi awukwazi ukuthi umsebenzi obelonga kwi-state u-assign to a private individual. The state remains the custodian of that work. It also provides a revision right for web copyright in a literal or music work was assigned by an author and shall only be valid for a period of up to 25 years. Isithi lekhona ukuthi uma umuntu okuyena umnikazi womsebenzi assigna ilungelo lakhe komunye umuntu, lokho kwenzeka kube valid iminyaka kuphela ewu-25 from the date of such assignment. Such a license can be verbal or in writing. Iyavuma ukuthi ke kodwa ke lezo ivumelano zibe nangomlomo zingabhalwa kuphela. Revision clauses are not new to legal frameworks, whether in the US or UK, for different types of work. The bill limits the assignment to this work as a result of Copyright Review Commission. The importance of this is that 25 years has been benchmarked as a sufficient period to recoup the investment made in the work and to make a profit. It also allows the negotiation or brokering of a new agreement after 25 years. Historically, in contractual terms, author signed the commercial right to publisher or producer and forfeit the right to economical exploit the work. Into ebijwayele ukwenzeka ke in terms of lezi vumelwano, umnikazi omsebenzi ube assigna amalungelo akhe okuthola awahambise assign ama agreement awanike ama publisher lawa ubuyibona abakhipha lemisebenzi to the public or abaproducer isikhathi esiningi kuba abaculi whereby umculi uassigna ama rights akhe kulelo cule kuma publishers nama producers and forfeit the right to economical exploit the work. Lo mthetho kuzama ukushintsha konke lokho ingakho kunesiphakamiso ukuthi kufanele kube nama standard contractual terms akhona ukuvikela lamacili ukuthi engalokho esayina away their own rights. The clause 26 of the bill proposed the insertion into Act of a new section, which is 22A, making provision for licenses in respect of orphan work. The clause provides a procedure of how to address orphan works, with the process administered by the Commission. The clause provides for orphan works for resale royal rights. Kuyenzeka-ke la kube khona ama royalties or imisebenzi lesithi imisebenzi eyintanda ngesiphecelezi ngesiZulu eyintandane. Imisebenzi la engakwazi ukuthi kutholakala ukuthi umnikazi wayo ubani noma bemazi kodwa bengamazi ukuthi ukephi. Umthetho-ke ube usuwenza ama provision ukuthi those work are called orphan works. Basuke nabo-ke bengazi-ke labo abawagcinayo ngoba isikhathi esiningi la egcinwa khona ila ngithe khona kuba khona ukuthi bonke abantu bayakwazi ukuthi banokuhlomula through ama collecting societies. Kuba khona uthola ukuthi mhlawumbe moya kwi-website yeSambro uyabona ngike ngaya nje insukwini kwi-website yeSambro whereby baya advertise ukuthi they are royalties which are unclaimed. Basho njalo ku-website yakhona basuke be-advertise ukuthi i-copyright ownership abazi ukuthi it's unknown or it's known but abamazi ukuthi ukephi. So they use the issue of i-website yabo moya kwi-Sambro uzobona ukuthi unclaimed royalties. Bazama ukuthi izinye indlela ukuthi bethola abanikazi ukuze bekwazi ukuthi bekhokheleke. Ngoba ngishilo ukuthi uSambro ezinye zeyinhlaka esithi ama collecting society. Isikhathi esiningi ke kubaculu ke abaningi vele eSouth Africa ba-affiliate kuyona iSambro and ngithi yona yodwa dominant. Kukhona lento ekuthiwa yini imonopoly whereby abaculi abaningi bangaphansi kweSambro ekuyiyona collector on their behalf. Clause 27 ukhuluma nge-accreditation, administration and regulation of collecting society. Ikhuluma ngoSambro ke la. Bekufanele ukuthi kushicilele umthetho ozokwazi ukuthi nawo lama collecting society kufuna anikwe accreditation. Ikephi la khona wona afuneka register khona. Ngike ngasho ngaphambili ukuthi bona ba register kufanele ba register ngaphansi kohlaka ekuthiwa its companies and intellectual properties commission okuyi-CIPC. Bonke ke laba ama collecting society are register ngaphansi kwakhe. Ingakho kubalulekile ukuthi bathole accreditation ukuthi no minister and collect on behalf of these artists. Bese thina sibakhokhela ama royalties. Ileyo process ekhona echazwa la clause 27 introduced ile copyright amendment bill. Copyright management information clause 28 of the bill proposed an amendment to section 23 of the act by providing for an offense if a person tampers with information managing copyright or abuses copyright and technological protection measures. Ngoba sengishilo ukuthi ke if kukhona any copyright infringement ngabe ngokwe-information noma ngokwe-xhakaxhaka lokho sithi technology, labo bantu kuye kufanele ukuthi babe khona ukuthi bathole kuconsider ukuthi leyo nto abayenzayo iphambene nomthetho bavela ngaphansi kwe-Copyright Tribunal ngoba zonke izinto ezihlanganisa i-Copyright Act zidingidwa zixoxwe kuthathwe inqumo ukuthi ama-sanctions le Copyright Tribunal inamandla to subpoena if let's say ifuna wena ukuthi uzo-appearisa uzothola ubufakazi inikiwe lawo mandla ukuthi kusubpoene kuze nama-document uzofakaza ukuthi wena ukuze kuresolve i-case inikiwe futhi amandla ukuthi sithathe iy'nqumo njengenkantolo iy'nqumo zabo zi-also binding awukwazi ukuthi hayi isinqumo sakhona hayi ngeke ngikwazi ukusilandela isinqumo sakhona it's binding. Clause 29 of the bill proposed an amendment to section 27 of the Act by inserting a new subsection which provides for an offense if a person unlawfully circumvents technological protection measures applied by the author or copyright owner. It also provides for penalties where the convicted person is not a natural person. It happens that umuntu otholwe infringe the copyright is not a natural person. A natural person umuntu ofana nami njengawe. Kodwa kuyenzeka ukuthi umuntu kube inkampani, for example, a legal entity. Inkampani ke meyiphule le mithetho kuyenzeka ukuthi bejezise ngenzu eyenzile lokho esithi is a turnover of within a financial year. Ezinye zeyinqumo ezithathwayo i-Copyright Tribunal and provide for offences in respect of communicating and making available the work to the public. Besesigilile nakho wire and wireless means. Ezinye ke imithetho ekhona ngaphansi kwalomthetho esithi Copyright Tribunal. Okuningi sengizamile ukuthi ngikhave kodwa sengifisa ukuthi ngiwelele kulomthetho lo omunye wesibili. Singakahambi isikhathi lo esithi Perfomers Protection Amendment Bill. Ngoba njengoba sishilo ukuthi imithetho zivivinyo la esichibiyelayo mibili. I-Copyright Amendment Bill amenda umthetho owashawa ngo-1978. Uyabona ukuthi washawa ngesikhathi kusekhona bandlululo sesikhona i-constitution manje esikhona sesinomthetho sisekelo sesiphila ngaphansi kwe-constitutional democracy. Kubalulekile ukuthi yonke le mithetho which is not in line with the constitution to review it so that it is not declared by the Constitutional Court to be unconstitutional. Ezinye ke inhloso or ama-objective alo mthetho lo esithi the Perfomers Protection Amendment Act is to amend the Perfomers Protection Act of 1967. Uyabona ukuthi le mithetho le imdala kanjani. I-copyright eka-1978. I-Perfomers Protection eka-1967. Kubalulekile ukuthi ke le mithetho ibuyekezwe ukuthi ihambisane nenqubo esesiphila kuyona. Ngoba sengishilo ukuthi there are international treaties that we've become a signature, that we have signed. It is important, therefore, for our country to ensure that they are also aligning their legislations to be in line with international treaties, to be in line with common law, to be in line with the Constitution, with the in line with the fourth industrial revolution, digital. Inhloso ke lo mthetho ukuthi ushintshe lo mthetho lo ka-1967 and also to provide for performers' economic rights. Kufanele ukuthi kube khona amalungelo akhona azomnotho ama-performers. To extend moral rights to performers in audiovisual fixation. Provide for the transfer of rights where a performer consent to fixation of a performance. Provide for the protection of rights of producers of sound recordings. Yesakhuluma ukuthi ke la ila khona ke beku transfer amalungelo umuntu anawo nje ukuthi belungelo ukuthi into yakho umculo kuzofanele ukuthi ke manje leyo ngoma usuyibhalile ngoba mhlawumbe udecide ukuthi no ngeke ngize ngicule mina ngoba ngeke ngicule kahle ngizonika omunye umuntu ozoyicula ufuna ngibe nesivumelano lo muntu bese siyabona ukuthi hayi ukuze le ngoma ibe mnandi kuzofuneka ukuthi mhlawumbe sithola uproducer uTira mhlawumbe for example they choose ukuthi now uproducer simfunayo kufanele sibe nesivumelano futhi manje isivumelano sesiphakathi kombhali weculo umculi producer siphinde futhi sibe nesivumelwano esizoba naso nomuntu okuyena ozosipublicize le ngoma nomuntu ozowenza lento sithi ama sound recordings ngoba ingoma ngeke izigcine nje ngokucula kufanele kube khona futhi ne musical video so broadcasting kufanele kube namanye ivumelano esizenzayo njengama performers lomthetho ke uyagqugquzela ukuthi kube khona if ivumelano zenzeka sikubhale phansi konke lokho ezinye zezinto is to broaden the restriction on the use of performances. It extends the application of restriction on the use of performances to audiovisual fixation. It also provides royalties, equitable remuneration to be payable when a performance is sold or rented out. Ngizokhumbula ukuthi the principle leyo ukuthi mekukhona i-resale of royalty commercially kufanele kube khona ukukhokhela kwama-royalties kwe-copyright owner siyayithola futhi le principle kwi-copyright amendment bill ingakho ngisho ukuthi i-copyright amendment bill the performers protection amendment bill ihamba lemthetho ihamba yombili ngoba iyamawele both these bills are intertwined interwoven interlinked ayahambisana yonke lemthetho awukwazi ukuthi usebenzise omunye ungawusebenzisi ngoba inhloso nqangi yayo yombili lemthetho ukuvikelani amaciko ukuze ngemsebenzi yabo abekwazi ukuthi bethole imhlomulo ebafanele iyona inhloso ekhona kule mthetho yombili mongathi uyayisonga uyayigoqa umuntu bekubuza ukuthi le mthetho ephakanyiswayo yombili yini inhloso nqangi yabo ukuvikela amaciko ngemsebenzi yabo nokwenza isiqiniseko ukuthi bayakwazi ukuthi behlomule economically commercially if dayisa imisebenzi yabo ngendlela ekufanele ukuthi bahlomule ngayo it also this bill it provides for recordal and reporting of certain acts and to provide for an offense in relation thereto to extend exception from prohibition to audiovisual fixation and sound recordings njengoba ne-copyright nayo ibiyenza and to provide for the minister to prescribe compulsory standard contractual terms as well as guidelines for a performer to grant consent under this act. Yaphinda futhi lo mthetho ukuthi kuzofanele ukuthi ungqongqoshe kwaka trade industry and competition kufanele yenze isiqiniseko ukuthi kunama terms afakwayo aphoqayo angeke zebe option they are going to be compulsory uma kwenziwa lezi ivumelwano kukhona ama terms okuvikela amaciko ekufanele kafakwe ngoba kubonakala ukuthi amaciko ayalahlekelwa kakhulu inzuzo yemisebenzi yabo to provide for prohibited conduct and exception in respect of technological protection measures and copyright management information respectively. Yaphinda futhi nayo njengoba ngishilo ukuthi le mithetho iyahambisana. So khumbula ukuthi nayo copyright protector in terms of technological protection. There are measures which are there in place. Nakuyona ke performers kunama technological measures in place to protect wona amaciko. Nayo futhi i-performance protection inawo ama-offenses nama-penalties nayo ekufanele ukuthi nakhona nabo bane-tribunal nabo futhi. Ingakho ngisho ukuthi le mithetho le iyahambisana. Ngicabanga ukuthi iphinda izinto ezitholayo ngala. Njengokuthi ama-definition, i-audio-visual fixation or broadcast, uyabathola kwi-copyright ukuthi bachaza ukuthini. The same definition nangapha kwi-performers protection amendment bill uyawathola. Lento yenza ukuthi siconclude ukuthi le mithetho iyahambisana. Ngoba into ethola ngala nangala uyayithola. So behlalo ngaba uphinda into eyodwa. Bese ngiphinda into esengichazile under i-copyright amendment bill ngoba siphinde sithole indaba zo transfers, former rights, indaba zo sound recording, performance, siphinde sithole nangapha ku performance protection, indaba zo protection of rights of producers ngoba nangala o-producer bakhona, nangala o-publisher bakhona, nangalana ama-owners of work akhona, nangala futhi kunama-restrictions lawa esiwatholayo ngala, nangala kukhona indaba ye-technology. Kafishane nje sihlalo ngizosho ukuthi ngizoma lapho kule mithetho echibiyelayo kafishane nje umuntu uzamile ukuthi egoqe. Ngiyazi ukuthi angizange ngibe mude kodwa kuningi engikushiyile. Ngizamile nje ukuthi ngigoqe ukuze sikwazi ukuthi sicaciseleke ukuthi le mtheshwana lesichibiyelayo ikhuluma ngani. Sihlalo ake ngishenxe ngegama elithi sesizolindela imibuzo yencaciso nabafuna nje ukuphefumula ukukhuluma kodwa mayelana nale mithetho sivivinye ichibiyelayo. Kubalekile ukuthi kulesi sikhathi esinikwe zona sisebenzise le platform engage on these two bills. Nginaye uza kwethu nawe uzonginekelela osuka ongikhohliwe ukusho ukuthi la sijoyinwe uza kwethu osuka kwi-Department of Trade, Industry and Competition ePitoli. Dadewethu ulungile Buthelezi sijoyinwe yena uMashenge naye. Ayisihlala asibonge sihlala.
Ngicela sishayele uthele izandla. Ngepresentation sizonika ke manje ithuba for imibuzo. Ngcaciso noma la sifuna khona ukubeka imbono. Amthone uthatha lo mbhobho noma khona omunye khona awukhona lapho. I'm told there is a Clementine from DTI who has joined us also, Chief Director ozolekelela kulolu hlelo sizoqala uma siqhubeka nalo. Baphinjoy bamhlonishwa uNtombi uSibhidla sibonge sikwamukele emhlonishwa. Sizonika ke ithuba manje bakwethu makhona banemibuzo ngcaciso wabafuna ukubeka imbono. Uzophakamisa isandla uzisho igama lakho. Uma khona inhlangano yemeli zama creatives noma ngiwena siqu, uma ikhona inhlangano yemeli usitshele nayo for ama record wethu ngoba khona abanye bamela ama organization. Uma uwena ngiwena futhi is fine, akunankinga ngalokho. Ngicela ke ukuthatha izandla uma khona sifuna ukuba nemibuzo. Sobona nje u 1 2 3 kube number 4 mfowethu emuva. Manje sivele ngefastela kangikwazi usikhomba, lena sikhomba ngaphakathi emeetingini. Ngena ngaphakathi emeeting bese siyakhomba, mama uvela ngefastela njena angazi. Ngicela siqale ngalabo abala ngaphakathi kuqala basaphakamisile.
Ngiyabonga kakhulu Chairman nama members we portfolio committee and our esteemed guests from DTIC. Mina igama nguThabo Makenede. My multi-choice, which is a broadcasting company. Our brands include DSTV, SuperSport, Showmax, and so on. Also, new chairperson of the National Association of Broadcasters. She represents Wongama broadcasters in the country, from television, public broadcasting, community radio, community television, and so on. Chair, I'm hoping in 5 minutes just to air our views on the two bills. Firstly, we support the bills as multi-choice. We support the bills as the NAB. But what we believe is that there are changes that need to be made to the bill. And let me put it into a context. The multi-choice will operate in 50 countries in the continent, DSTV platform. The Showmax operates in the 50 countries. We also operate in Europe, in Asia, and in North America and South America. So whatever we decide in South Africa around performers and copyright and so on, it affects what happens in those other countries that we operate in. And it's not just only us. We have Netflix who are competing with us. We have Amazon who are competing with us. They also have performers. They commission a lot of work, and that work I challenge in South Africa. It's represented throughout the continent. So we need to these bills must balance the needs of, firstly, the creators who are creating the works. They invest a lot of time in creating the works. There are performers who invest a lot of time in actually performing, and they have a lot of skills as well. We are investors as well, because producer and audiovisual work costs a lot of money. I will give you a case study, a recent case study that we just did. It costs a lot of money, so we need to balance even that investment that comes in. We are the distributors who make sure that the content reaches everywhere that it needs to reach. But also, the most important aspect, I believe, is the consumers, abantu who are consuming the content that is created. Because whether you create a piece of content or even it doesn't matter. So we want to go to Amabili, they must balance the needs of everyone in the value chain, because it's a big value chain. When research was done that led to actual, a lot of research was done mainly on the music industry. The music industry it's a small section of the entire audiovisual industry, right? How the issue of royalties and so on came, it was looking at the music industry, and we've had many presentations. A lot of our artists have died poor, right? But that's only the music industry. It did not look at the broadcasting industry. And if you look at the time when the research was done, which was around from 2013 up to 2016, streaming had not been launched in South Africa. Multi-choice, we launched Showmax, which was the first platform in South Africa in 2015. Netflix came in 2016. So it did not consider what happens on the internet around royalties and how we deal with our performers. So it means we are basing a lot of the information on what happened in the past and not what is happening currently. So there are some tweaks that need to be made in the bills. Firstly, let me begin with the copyright bill. There are 3 items that I need to look at. It looks at a one-size-fits-all of managing your copyright. And there isn't a one-size-fits-all, right? Go audiovisual in broadcasting, copyright is dealt with much different from how it is dealt with in music, how it is dealt with in written works, right? So we need to have a nuanced approach that looks at what's happening in different industries and come with a section of the bill that we look at to cover all the different industries. Ukuthi isn't a one size fits all. It won't work. In fact, it will create more harm than it's actually trying to fix. The second portion is AMA royalties. The bill talks about ukuthi the minister will set the royalty rates. The minister will determine the royalties, and the creators of the works will actually only be paid in royalties. Now, there is a problem with that because you want AMA royalties, yes, which is one form of payment, but there's another form of payment, and the Performers Protection Bill talks about equitable remuneration. There's royalties or equitable remuneration. And I'll make an example. An experienced actress, for instance, or an experienced creator of a series will decide to go to Yazini because I know the risks with AMA series. AMA series are not always successful. I know the risks with AMA series. When I negotiate, I want upfront. I want R1 million upfront. Whether it becomes successful or unsuccessful is not my problem, right? Some people actually negotiate like that, especially the experienced ones, right? When you say only AMA royalties only gets paid when a show becomes successful. When it's a failure, you don't get paid anything, but you've already done the work. So it should be that we give the option of royalties or equitable remuneration. Another third option, Chair, we talk about copyright, but we forget one of the most important things that is happening right now, piracy. Piracy, a lot of creators are robbed of their work because of internet piracy. You create a series you're expecting to be paid, someone makes it available on the internet, everyone watches it for free. You are not getting paid for that work. Copyright should actually look at internet privacy. It should look at piracy in the copyright bill. I know initially in the discussions, in the initial discussions, there's now around the Electronic Communications and Transactions Act. But if you look at how copyright is dealt with in that act, right, which is the purview of the Department of Justice, if you look at how copyright is dealt with, I have to go to court, neutrally court order, and then I will shut down the piracy site. With sports, for instance, when soccer is playing, there is no time to go to court. The copyright bill should cater for that I must immediately, when I see there is piracy, I must immediately issue an instruction to your service provider, but you need to shut down the site without having to go to court. So that protects the copyright of the creators. Who performance bill, there's very few that actually needs to be fixed. The issue of the remuneration, yes, but there's the big issue with performers that talks about reporting. The onerous reporting is too much even for the department to handle. It's too much even for the performers to handle. It's too much for the broadcasters to handle. An example is multi-choice. We have over 150 channels on our platform, right? On a monthly basis, there are close to 5 million performances. According to the reporting at the bill, we'd have to report 5 million performances on a monthly basis. That means we will not afford it. We will lose money and we won't invest as much money as we do. So the reporting is already happening. When we have to pay our royalties, we have to report on the performances. But to say that we have to report it on a monthly basis, and if you look at it, actually worse than if you infringe on copyright itself. Another issue is the contractual terms. We don't think a minister should be able to set contractual terms. Just to say that our contracts needs to have 1, 2, 3 issues. When contracts are not lawful, there is the tribunal that can deal with that. Many industries have tribunals already that are already dealing with unlawful contracts, where 2 parties sign a contract, 1 party is disadvantaged because of the contract. It goes to the tribunal deals with it and actually sets aside the contract. So it's important that we allow the creators, we allow the investors, we allow the distributors to actually negotiate around the contract and agree. Thank you, Chair.
Let's move to number 2.
Thank you very much. Greetings. Artist akhona namhlanje ngiphinde ngibingelela abahleli ngaphambili. Igama ulindo kuhle isibongo Hadebe. Ngabe ngenza iphutha ke bengingaqali nje ngokusho nje lokho kubalulekile ukuthi long live to President Vladimir Putin. We must emphasize ukuthi we support what he's doing in Ukraine. Phela ke sibeke ngokusobala ukuthi lo mthetho oshicilelwayo namhlanje njengoba sizwe ukuthi khona abaka multi choice who have denied us a chance to even hear inside the Russia by crushing our channels, including Russia Today. So they are here today as we can hear ukuthi this bill is initially serving their interest. Njengoba sizwe ukuthi kunemithetho eyashicilelwa ngezikhathi zobandlululo kusaphila uhulumeni noma obhoda okusho ukuthi le mthetho ayisevi ama-interest abantu abamnyama. That's why sizwa kahle ukuthi kulama bill there is a citation of international law of which it serves the interest of what we call the rule-based world order. So masikhuluma nge-rules-based world order, we are perpetually talking about the interest of the West, of which multi-choice they are serving those interests as per the mandate of the Stellenbosch mafia, white monopoly capital. So initially, I would say it initially should be rejected on those bases. It is continuing to serve our interest only one. Initially, it's important with even our artists. Because at the end, this bill will continue to make them starve. It will continue to make them without any financial stability. So, as all multi-choice they are indicating they are supporting this bill. So, my suggestion is that the state must play a critical role, a huge role, in making sure that our artists are protected in terms of our copyright and even including our performance protection. On the basis that the state must provide assistance in terms of making it easy with our artists that our resources. Because once you talk about is it final copyright, all those things, what do you say about a person who does not have our resources in terms of studio, all those things, to record that particular music? They would have to go to multi-choices so that they can help them. So on those grounds, multi-choice, they would want to own maybe 90% of those royalties. So it becomes important with state play a very vital role in making it a point which artists have the ability to initially have ownership of their royalties on the basis which they must be provided with those working material. So that's the multi-choice because kumele sazi ukuthi bengaba ama-bill ezo-support multi-choice kusho ukuthi ugovernment wase-South Africa, ugovernment waKwaZulu-Natal is initially selling out abantu abamnyama who have been oppressed for over 200 years. So that's why ngithi kuyiphutha elikhulu ukuthi it is 2023 manje, we are still having ama-laws that are governing South Africa that were mandated or gazetted during izikhathi kusaphethe amabhunu obandlululo encindezelo. Kubalulekile ukuthi ngibonge kakhulu uhulumeni waKwaZulu-Natal ukuthi alawe iRussia neChina to conduct ama-military drills. Yinto enhle kakhulu, sithemba ukuthi nohulumeni wase-South Africa uzovumela futhi ukuthi in particular KwaZulu-Natal will be able to see a permanent military base here, China and Russia, of which those are our biggest allies. And also, it becomes important as we are making these bills, we must initially take note to our biggest allies, which are in the BRICS alliance, because as it stands, le bill njengoba ngishilo ukuthi serve ama-interest west of which it is America, rule-based world order, as it then becomes important ukuthi senze imithetho esoyithatha from i-BRICS alliance, njengoba sazi ukuthi South Africa is chairing that particular alliance, i-BRICS. So we must take in information from our allies, our biggest allies, njengoba sazi ukuthi vele by 2030 kuzobe sekumlando ukuthi China, USA is the world leading economy. So it becomes important ukuthi sithathe noma sifunde from China, who are initially becoming the world leaders and who will be the leaders of the new world order. So as it stands, ngithi le bill my reject and sense the show ukuthi i-state will play a pivotal role ukuze sizo-avoid ukuthi multi-choice basicishele Russia today, because we also want to hear the side of Russia. We also want to hear the side of those others who are involved at the global space, and also sinikeze ukuze sinikeze ama-artist ipower eyanele sisuke kwiziqhwaga ezo-multi-choice, because as they say that they are accepting this bill, it actually means abantu abamnyama bazoqhubeka benze i-craft yabo, and i-craft yabo izodliwa izinkampani ezinkulu. Ngiyabonga kakhulu. Thank you very much.
Ngiyabingelela bahlali ngaphambili kwi-presidium elidwa usihlalo we-portfolio committee uNtombela Nyamazana. Isibonelo advocate wakanzima kwisibongo, okuningi engizokhuluma ngako kuzoba ama-comment, not an actual submission. Kodwa ke futhi kunandi sihlale eSouth Africa ngoba uhambe ngendlela uzithola usufunda ngama-international balance of forces unaware, but there is no crisis. No, ngifuna ukuthi sihlalo, firstly we appreciate ukuthi we are given a space as a community or as different stakeholders to partake kuma discussions afana lawa noma ukubeka imbono ekutheni yini esicabangayo ngeyihlabane noma ngabantu bezamaciko. Yize ke sihlalo noma imessage ngiyithola izolo ntambama ukuthi namhlanje ufune ngibe la. Ngiyanixolela ngokuthi ni communicate late. Senzela ukuthi lingenzeki iphutha elifanayo ngokuzayo.
Why broadcasters are not paying collecting societies and why collecting societies are not paying record companies and artists. Incidentally, at that time, I was representing the SABC. My colleague at MultiChoice, just in case he thinks I was representing the other side. But the purpose of the task team was to find solutions that will ensure that in the end, the very people that all of us are fighting for, our artists, are actually paid. The task team made recommendations which resulted in the first copyright amendment bill. So in 2015, we had the copyright amendment bill driven in the main by those recommendations from the Falam Commission or the Falam task team. Because if I say commission, we're thinking of Marikana, but it's the same judge that sat on the task team on the music industry. So that's the history of how we got here. And that bill incidentally included both performers and copyright issues and was rejected by everyone to a point where another task team was formed. And that task team looked into the performers protection amendments. So it separated performers issues from copyright issues. And that's why we ended up with the two bills. They then went to cabinet approved, and I'll fast track, Chair, I know I'm taking too much time. Cabinet approved, the portfolio committee rejected those bills and then started drafting the bills themselves. So it was then, and that's why it's called the B bill. The portfolio committee then drafted the bills. It then started as an alignment to, as you said, the WIPO Performances and Phonograms Treaty, the WIPO Copyright Treaty, the Beijing Treaty, as well as the Marrakesh Treaty. The president, as you said, rejected, didn't sign the bill because of constitutional challenges, sent them back. And this, obviously, as I said, started 2015, and this was in 2018, president rejects in 2020. We are back to almost square one. What I would advise the committee, because of the mistake that was made in tagging the bills as 76, instead of 75, as you said, it resulted in a delay. And I am worried that the way in which we are going with some of the concerns that are raised by the industry, I'm not sure if committee members listened yesterday to the NCOP, the presentations that happened yesterday. You will see there are serious concerns on some of the areas of the bill, one of which is fair use. I have been involved in the entertainment industry for a very long time, as a lawyer as well as an advisor and as a consultant. I don't know where this fair use come from, Check. It sort of came out of nowhere. We have been a fair dealing country for a very long time. Now, for you to change a policy, you need to do investigations. And I can tell you no investigations were done for us to move from fair dealing to fair use. There was no market failure, right? Because there has to be a market failure for us to change a policy. And I worry that when we go to the Constitutional Court, the minister is going to be asked, how did you come up with fair use? What informed fair use? Because it's changing policy. And what the department is not saying is that it wants us to be part of a club of less than 10. There are less than 10 countries that use fair use. Why us? Why should we be guinea pig? I mean, they've cited Israel and they're citing countries. Those countries, when you compare them, it doesn't mean they're innovative because of fair use. In fact, Australia did an in-depth study on fair use, including whether it complies with 3-step test, and it agreed that it complied, but rejected the policy of fair use. Australia, as we speak, does not have fair use. So you have those divisive, and fair use, by the way, is very divisive, because what it means is that our creators will create work, and if it is infringed by big tech companies, you have to go to the copyright tribunal. Spend almost the same amount of money fighting big tech companies that are trillion-dollar companies, right? And you will spend the whole time all the way to the Constitutional Court just to show that they have infringed your work. And once they've decided that, yes, the big tech company has infringed, what we don't have that the US has is punitive damages. In the US, they'll punish you because you took the court's time. Here, you are only going to be paid what you would have been paid had you licensed in the first place. How fair is that? You've spent so much money in court, but you are being paid money that says, if you had licensed in the first place, this is the money that will pay you. And I think the committee, the province, and I've said this in most provinces I've gone to, they need to understand the impact of these bills in their own creative sectors. It is easy for us to talk about international. The international guys conclude their agreements overseas. And by the way, when we talk about innovation, and we come up with AI, for instance, artificial generated content that can mimic our own artists and can produce thousands of sound recordings. How do we compete with those? Which are going to come back and say that's fair use. And America is the case where a community library copied all the books and digitized them. And when the publishers went for that community library, the community library said it was fair use. And their courts agreed with them. Where are we going to be as South Africa? We are a very small, we constitute 1% of the global market. How do we get to this point where we now want to push for a policy of fair use? So that's one. My view is park, and I know some of my comrades are saying, actually don't say park, they must just get rid of it. But in my view, if you want it, park it because it's divisive, do an in-depth, deep dive into the impact of fair use in South African creatives. And once you've done that, then you can come back and say, we've done the research and we believe this is how it will assist our creatives. So now I'm going to deal with some specific issues and I won't be long. The first one, we think it's a good idea for umculi to have their consent to the sound recording reverting after 25 years. But we've not actually understood how the music industry works. I, as a performing artist, have exclusive rights in terms of the Performers Protection Act. I can decide who must record me. But once I've decided, I then give consent to a person who's recording me. And that consent then means my performance can be recorded by someone else who's then going to own copyright in the sound recording. And remember, I'm not the only one. There's session musicians that have paid to be part of the song. There are guitarists, backing vocalists. All of those are performers in terms of the act. So after 25 years, firstly, mina as a featured artist, segmele your negotiator, I'm a session musician, backing vocalist for a royalty. And if one of them says no, or they say, I want to earn the same royalty as you in Tantrasibis, as the featured performer. And I say, but no, I'm the featured performer. And by the way, I paid you to take part in my song. And the session musician can say no. Because you've given them the right to say no in terms of this bill. And once they do that, that sound recording cannot be used, Chair. It means it's a sound recording that is going to be parked. How many recordings after 25 years are going to be parked? It's the problem of one size fit all. That's what the department did. It went for one size fit all. It didn't do an in-depth study in each of the sections that are affected by the Copyright Act. Instead, it decided to go to, imagine good sport, Chair, where you have one rule for a penalty that applies across all the sporting code, netball, rugby, and all of it won't work because each sporting code operates differently. And I think my appeal, honestly, to our own government is that they need to take care of our own creatives. It's important that they do. When they come up with legislation like this, they must be practical. I mean, the example of sound recording and the consent reverting after 25 years, it is not practical. You're unscrambling an egg. It's not possible. The owner of the sound recording still owns the sound recording. And the performance has reverted to the performers. Now you're sitting with an unusable sound recording. So all we're asking is be practical about it. Umpo raised an issue around the ministerial powers to prescribe contract. You might think it's good, and it would depend on which minister is there. What happens if another minister comes in and decides, actually, I must scrap royalties? Because you've given discretionary powers to the minister to prescribe contractual terms. It is a first that contractual terms can be prescribed. It doesn't happen in any other industry. Let's address issues and let's not cop out, because to me, it's a cop out. Instead of going to artists and saying, guys, how do we assist you so that we are able to benefit out of your own performances? We just say, no, we'll come up with a rule that says the minister will be the one that prescribes contractual terms. Another minister comes post-elections, what happens? You've already given the power. So I think let's be careful about what we are trying to do in terms of us engaging with our sectors. And I'm glad we are now. I'm going to wrap up, Chair. I'm glad we are now. And I like some of the input. But to be honest, think about South African creatives first. Because there is no creative that would accept fair use. Because what fair use does is to limit the rights that you have. So it's like me as a creative saying, yeah, but ngangibhadala salary encane because ngifuna ukuthi abantu basebenze umsebenzi wami for free. You can't, there is no creative that can, in their right minds, support fair use. It's not possible. People that support fair use are technology companies. And guess what? And guess where they come from? I don't have to say where, but we know. Some of which have spent just $1 billion the other day coming up with an AI, artificial intelligence, that can mimic any artist in the world. Now we have thousands of songs competing with our own artists. They can mimic Brenda Fassie. They can mimic Simon Kabindi, Umashatin. And they'll compete no music amateur because we are allowing it. So please, I beg you, before let's pass the bills, please amend them in such a way that they take into account our creatives with. And there are quick fixes. For instance, in the 25-year reversion, you can add subject to contract, and you've dealt with it. So it's subject to contract, it's easy, it's dealt with upfront. Fair use, as I said, you pack it. Prescription of contractual term by the minister, if you want him to do guidelines, then say so. Don't come up and say, minister can prescribe contracts. On the payment of royalties without an option of a once-off, you are basically saying in the music industry, my dancers must be paid a royalty. And as he said, rightly so. If I'm a dancer, I want to be paid upfront because I don't know if that music video is going to make money. And if it doesn't make money, I would have de-risked by being paid upfront. But being forced to take royalties on a project that I don't know whether it's going to succeed, it is unfair. And Chair, let me end there. There's a lot that we can discuss. As I said, I've been involved in this industry from a legal point of view as well as from, in fact, I was part of the advisory committee on trade and industry. And we've had our own views on the issue. So thank you so much. And I think I'll just stop there.
Sibonga. So khona ke izandla eziqhamukile after lezo 4 ebeqhamuke eqaleni. Cela uyibheka ngibone khona besiphakamile la isandla. Angisibonanga besiphakamile. Lesibesivele ngewindi. Oh, hayi inkingi leyo ke besivele ngewindi. Ngisho lesivele ngewindi asibonakali. Yabo 1 2 ezogcina ngisho samanye 1 2 3 igcine ngawe bafo sobo number 3 sis ezogcina ke angichaze bakwethu this process was starting as we start the process there is nothing stopping you as an organization as an individual even to do written submissions on the act as we are noting down in initial but none on your own, you can write your own submission with detailed workshop. No, we think the act must be amended in this way to cater for 1 or 2 or 3 or 4.
Sanibonani, igama lami uJudith Somhlaba. I'm a performing artist, a songwriter, and a vocalist. So, eyami indaba ithi, thank you from abafowethu sebekhulumile and thanks for the opportunity. And ngizwile konke okushiwo and I'm collecting the information. I can't make a decision yet ukuthi ngivumelana nani angivumelani nani at the moment. But from my experience, my challenges esike sibe nawo engizocela ukukhuluma nawo eyokuqala is about ama-backing vocalists. Ama-backing vocalists are the only people engazi ukuthi abakho protected imithetho esilawulayo, and I'm so grateful ukuthi after such a long time, 1967 is a long time, senze decide ukuthi you're going to amend imithetho yethu, which I've been watching from a distance. Kungathi sinama music industries out to khona abelungu khona neabantu abamnyama. As a result, mawuyako izindawo ezifana nabo Samro, you don't usually see abelungu bezo complain about most of the stuff that we always have to complain about. And then now ngibuyele kule ndaba yama-backing vocalists. Ama-backing vocalists are a problem afacena now, as I have been one myself. Mawuya a studio to record, ayikho into yokuprotectayo, and sometimes you don't even sign a contract ukuthi I'm giving my PVs for this project. Akuna flat standard, a flat rate ekuthiwa, okay, for example, abantu abasebenza emakishini, there's a rate ekuthiwa per hour I'm going to earn so much. But for ama-backing vocalists, which in this case abonakala sengathi abantu abasebenza abanye abantu futhi bagcina benyatheka most of the times, bona ayikho i-rate ekuthiwa, okay, asimkhokheli kancane kunalokhu. They are always they are the most exploited people in the world, and ngicela sibheke leyo. That's ngiyayibona leyo ukuthi we want to amend, we want to merge or whatever. Khona abantu abayi-understand ngcono who can make a decision okwangoku. I'm not going to talk about that. So ngizokhuluma ngezinto nje that I would like our government to look deep into. So ile ama-backing vocalists, yes. So bengizocela ukuthi whenever you talk about these things, just remember them ukuthi they really need your protection kakhulu, because most of them umuntu uyalapha yana engekazazi izinto eziningi about the music industry. And secondly, I would like to talk about our churches. Our churches are the greatest, biggest, hugest exploiter in the whole world. Looking at ukuthi mangiya esontweni as a musician, performer, whatever I am. So bazongibiza and ask me ukuthi they want me to be involved in their worship team. But if kuza umuntu la ethi mina ngiwudoctor, mina ngikwazi ukufaka ama-tiles, we building a church, they pay those people without saying anything. But when it comes to us as vocalists, they will emotionally blackmail us ngokuthi do it for God. How can I do it for God when you as a pastor, you're getting paid? But mina, this is my, yes. And Lena, this is my profession. But why do you say you're not going to pay me if I do it in your church when you can pay for a doctor, my consultant? Esontala. Uyenza kanjani leyo nto? So bengizocela mhlekazi uhambo wabaceba ukuthi bayase-exploiter igama likaJesu, and siyamthanda uJesu, but now sigcina sesingasamthandisisi because of them, and akusowa. Yebo leyo. So bengizocela, okay, ngicela ukubuyela kule nto ukuthi why am I saying that? I'm saying that because I've been involved in both ngizothi the white churches and the black churches. In the white churches, you get paid when you do that. Why can't it happen to us? And sometimes, if you go to the white churches, you'll find out ukuthi wena as a black person, because they think you don't know, they will not pay you. Among all the people, it happened to me for about 8 years. They will not pay you as umuntu omnyama, standing there with all these people. You uzobona nje umuntu uyafika and impilo lokishintsha phambi kwakho. You are there, you're doing the same job. The only thing abazoyenza kuwo bazoku-ofara umsebenzinyana nje omncane in the church. So now you are doing 2 jobs. The other one you are paying, you bought the one engacacanga that you're doing in the church, but you are doing your actual job every day. And actually, you are the one who does the most. We are on. So ngicela nambe nobaceba nikhiphe umthetho. Nikhiphe umthetho oneyindlebe namehlo, if possible namazinyo, ozogovern bona, because bona they take from the community. In as much as they are a non-profit organization, they take from the community, but they're not giving back to the community, and yet they want quality. So that's just all. It was just my 2 concerns that I want to beg you, literally ask you, Uguti, look at it in case there's somebody, there's never been anyone talking about it. Thank you.
Let's go number 2.
Sanibona njani?
Yebo.
Usandile lo ngubani? Ngiphuma eSite TVET College. Ngispecialize ku music kakhulu kodwa ngisukuma on behalf of abadansi. I-practice engekho familiar ngayo kodwa khona into esho ubhuti lo waka multi choice ukuthi ibill iyayithande ukufavor uhlobo lodwa lo creator. So bengifuna ukwazi ukuthi ibill meyenziwa iba accommodate kangakanani abantu abangabadansi, ngoba ngibone ngazi ukuthi abanye babantu esibakhohlwayo labo. Ngizokwenza example justify umbuzo wami or suggestion yami. Ngike ngalandela istory se movie The Hangover. Uno Mike Tyson lapha une tattoo la. So i-copywriter leyo tattoo i-design i-ownwa i-tattooist ya Mike Tyson. But in the movie another character uvuka should balala bedakiwe avuke sebemenza i-tattoo. But that tattoo ifana nale ya Mike Tyson. So before the movie i-release i-tattooist ya Mike Tyson yaba namandla okumisa i-movie ukuthi you cannot release this movie because you have copied my creation, which was between mina no Mike Tyson, wayifaka on another person's face. So they went to court. I believe the tattooist was compensated kahle. Yaqhubeka i-movie ya-release. Now umdansi ngizosebenzisa i-example yeGwaragwara. iGwaragwara sonke siyayazi ya DJ Bongs. It's unique. I-copyright ke ithi to be protected under i-copyright lo msebenzi kumele ube unique. It must be very different from anything out there, angithi. It must be original, and kumele ibe reduced into a recorded form. So now iGwaragwara uBongs uyayenza uyayishoot. It's unique, it's original, and useyirecordile. Siyayibona iyatrenda. Nangu umuntu wemovie somewhere in another country uproduce imovie yakhe. Kule movie kunomuntu ongayena uDJ Bongs udansa iGwaragwara emovie. Akhona ama benefits alokho. It's a trending dance. It's all over the world. Ikhona yini ke iprovision kwibill ukuvikela abadansi ukuthi abe nawo amandla ukuthi if kukhona osebenzisa umdanso wakhe, which is a sequence of ama moves, akwazi ukuthi abe namandla athi ngicela ukuhlomula lapha nami. Ngiyabonga.
Number 3 lapha emuva. Sengikhuluma umfowethu inkosi yamabhincu ngizwe ukwabopha uMTN ethu ayikhale igama lakhe lelo ibrand yakhe kumele bamkhokhele ngalo. Wozama.
Sanibonani, igama lami uNosipho kaMjaji. Ngifunda lapha eSite TVET College. I'm doing music performance, my N6. So okokuqala ngizoqala ngifake i-compliment. Siyabonga kakhulu. In my experience sengiphilile for the first time ngibona ama-artist ethathwa ngizothi ebeke ezingeni eliphezulu. I-complaint yami ithi as ama-artist we are being neglected, to be honest. Mungathi uyabheka kuma-colleges kuma college for abantu mhlambe from rural areas mhlambe abangakwazi ukuthi bangene ema universities. Mesingathi siyabala mangakho ama colleges that have music. The reason why ngisho kanjalo ukuthi as ama young artist, if ever you've got the idea of a song or a beat or anything, then you come up with the artist elikhulu bayasiroba just because we've got no professional knowledge for music. So please, lokho maniphinde emuva siyacela bakithi siyanicela as a youth, ama programs akanje makande afake even on higher education for ama colleges, because kuma universities akhona there are students abangakwazi ukufinyelela on universities abakwazi ukufinyelela kuma college, then siyacela kakhulu lama programs akanje ande. And another thing, if ever usuqedile college, there's that 18 months for in-service training. Siyastrugglisha tina as ama artist or performing artist, as ama students, ukuthi sithole a program that ezosi-trainer. It's either you are in music business or you are a performer or you are a dancer, party siyastrugglisha besicela kakhulu. So another thing ebengifuna ukuyireza ukuthi siyacela ama programs akanje afike even kuma rural areas, because ama artists amaningi sigcina siba ama local artists siphelele lapho just because asinalo ulwazi, especially kuma contract sigcina sisaba thina because asinalo ulwazi, because nawe as an artist unelungelo lokuthi no le contract ukuthi nokuthi angekuthandi on this contract, siyasaba ukwenza lokho because asazi noma kumele ukwenze noma akumele ukwenze, sigcina sirobheka ugcina uba local artist kuphelele lapho ungakhuli as an artist. So siyacela kakhulu, and even ama companies that can provide a service training, mongathi ya comparisha ko hospitality naka PPP bayawa provider mostly nako business ama in-service training. Thina kwi department yethu or as ama artist, young growing artist, kunzima, to be honest, kunzima even to get a job or in-service training or anything that consent, where else art is everything that we live, everything we born, there was an idea from somebody. Thank you so much.
Thank you, ngiyabonga sihlalo. Disadvantage engengaba nayo yokuhlala emva kwespeaker esimnyama aphakamisa isandla esimnyama yaqala inkathazo. Kangabe ngisabonakala. Igama uHoward wakamsomi, the Provincial Secretary of Cultural and Creative Industries Federation of South Africa, KwaZulu-Natal. Profession yokuqala engangafisa ukuthi ngiyenze kwaba yilo. Then ekhaya ke they shoot me down. Bazibeka izathu ngabona futhi ukuthi ayanginayo ichoice. Fanele ngiyeke. But lokho kwenza ukuthi ngiqonde ukuthi mawufisa ukuba yilawyer, at least you will need a minimum of 3 to 5 years ufunda esikhungweni semfundo ephakeme. Now, mawubheka lama bills esikhuluma ngawo, akakhulumi nje nge-generic English or generic information. Isingisi sakhona seyiyeme noma sencikile ekutheni umthetho uyawazi yini. Now siyabonga ukuthi namhlanje njengamaciko siyakwazi ukuhlala la kuzozwakala uvo lwethu ukuthi thina sibona kanjani thina sithini. Kodwa mhlambe isifsa ke KZN ingithume nje ukuthi angikudlulisi ukuthi makuthiwa khona umlingo ongaba khona, siyadinga ukuthi siqale siyi-workshop ibill, ngoba ukwazi kwethu ukuthi njengoba sithi akube khona le mthetho uqinisekisa ukuthi mina engumnikazi wawo uyakwazi ukuthi ungibuyisele, mina engichithe isikhathi ngiwenza, akube yimina othola umphumela wakhona kunokuthi kube umuntu ongazange azawenza. Now the first point that I want to check is that how the bill is going to assist or to take care of a situation where the lifespan of our work becomes 25 years. Simply because after 25 years, asisakwazi ukuvumelana. Now kusho ukuthi lo msebenzi ngeke usaphinde usebenze usuhlezi lapha. and sicabanga ukuthi akuyona inhloso yokuthi umsebenzi uhlale lapha ya ungasebenzi. 2, amanye ama sections have been covered kuwona. Bese ngiya kule ka minister. But mhlambe it will be better if we say the minister can provide the guidelines, not to have a determination. Because as other colleagues have said, what if there are changes and so forth? It will give us a challenge. But we understand that uma sekunzima ubaba Mahlathini kuthiwa akanayo imali kanti siyamazi wenza umsebenzi omkhulu. Siyazi nohulumeni ke kubukela ukuthi uhulumeni ubukele nje abesethi uhulumeni hayi izandla zami are tight, I can't do anything. But at least if enganikeza ama guidelines ungakwazi ukuthi usilekelele kakhulu lokho. Bese zoba khona isiqhwaga ke la. Yabo isiqhwaga esingene ensimini yakho bese sikha umbila wakho utshale kanzima bese sithi hayi asihlangane lapha ekhalweni mangabe unenkinga uphatha uthu wakho nami ngiphatha uthu wami singakunikezi ke ongenani ku2. Yabona le FAUs is quite difficult. Yabona njengoba sikhuluma nohulumeni ngoba singabakho uhulumeni and uyasazi uyasiqonda kahle isimo sethu. Abanye bethu njengamaciko sike sibe necontract ebhalwe in black and white, and at times that contract is not honored and sayithatha siyeke, not necessarily because we do not want to pursue, but inkinga ukuthi moya ecourt kunamandla ekufanele ube nawo. Now if I use my isiqhatha neziqhwaga oba no Google nobani abathi hayi soyisebenzisa lento mawunenkinga ngalokho bathathe yona imali abayenze ngalo umsebenzi wakho bahambe bayozidefenda ngawo in court. They keep on postponing bathumela abantu abamele abathize bangezi kuzo advocate. Wena cishe ukuthi uzolifaka icala kanye mekela la postponewa bathi abamele hayi faka imali ndoda bese uthi hayi right akunankinga. Now sicela le FAUs ke siyenze investigation but how much is going to destroy the struggling artist. Lawe sithi they must be protected because le FAUs iyacacisa ukuthi ayishuthi soba nenkinga enkulu. Awukwazi ukuthatha umsebenzi wami without my permission uthi ngivumele ngiwuthathe bese sihlangane ecourt. Ngizofika kanjani ecourt ngingelawo namateko okuya khona? That will be a problem. I thank you, Chair.
Ngicela unsele nethimba lakhe ba responde bezela ngaphambili.
Bongestan. Cabanga ukuthi okuningi la bekuyimbono esibonga kakhulu ngoba eminye nathi iyasiqwashisa futhi iyasifundisa. Umuntu selokhu eqalile nje enza le bill usefunda okuningi abengakwazi before. Cabanga ukuthi okuningi ingakho besocela ukuthi nakuba eminye imbono siyithathile yokuthi iziphi iphakamiso abayiphakamisayo abafowethu ngoba phela le bill kakhulu uyabona mekukhona umuntu othi usebe khona kwi-industry iminyaka eminingi wagqoka igqoke ezihlukene waba advisor waba ummeli ngeke uzumdlule ngolwazi lo muntu analo ngoba kwi-industry. Ingakho bengizopropose ukuthi ama comment abo siyawanotha kodwa bese singacela ukuthola imininingwane ukuze sizocela ukuthi basibhalele phansi lezi phakamiso kakhulukazi abebekhuluma ngazo ama recommendation amanye anganakwanga nama consent ngoba azobaluleka ukuthi siphinde siwahlanganise njengoba sizokwenza umbiko ozohamba uye kwi-select committee ya National Council of Provinces ngoba njengoba sihlangana nani kanje sikhulumisana nani konke lokho enikushoyo siyakuqoqa ingakho futhi sigqugquzela ukuthi abanye abangakwazanga ukukhuluma ngoba kuye kuthiwe uyindoda noma ungakhulumanga kodwa babhale ukuze bekwazi labo bantu ukuthi imibono yabo ngoba khona abantu abangajwayele ukuthi bakhulume kodwa uyakwazi ukubhala besithumelele kuma-emails besifonele sizoyishiya imininingwane ngoba siyafuna ukuthi imibono yabo siyithole ukuze sikwazi ukuthi kwesinye isikhathi awukwazi ukucaptureisha kahle umbono womuntu uma ekhuluma kodwa mase bhale phansi uzokwazi ukuthi ucaptureishe kahle ukuze mase sihambisa ireport ezoqale i-adoptwe ikomiti kungabi khona umbono osala ngaphandle ngoba ngiyacabanga ukuthi yonke imibono ekhulumekile la ibalekile kakhulu futhi siyayibonga kakhulu ngicabanga ukuthi umuntu uzozama ukuthi mhlambe kube ukuthi uyaphendula kweminye imibuzo ebuzakele umfowethu la mengaphosisi ebekithi ngizomfuna ukuzomphendula ngokomthetho akhulume ngayo uSandile Ngubane okhuluma ngabadansi ngicabanga ukuthi yena umuntu laba abanye bebenza izincomo nje njengosisi uJane ukuthi asenze isiqiniseko ukuthi umthetho uyabavikela abantu abacula emasontweni amasonto engabaxhaphazi ngiyacabanga ukuthi lo mbono siyawuthatha sizobona ukuthi umthetho uzochibiyelwa kanjani ngoba phela kwesinye isikhathi abanye abantu isonto libhizinisi na kwabanye abantu isonto aliseyona nje indawo la khona lihlangana khona lidumisa uNkulunkulu kuphele kanjalo ukhona abantu asebethola imhlomulo ngokuba namasonto amasonto asamabhizinisi ingakho abanye sebenza isiqiniseko ukuthi even bademand ukuthi kube khona nemali ekhokhwayo standard ukuze kube khona i-sustainability yesonto ngoba ibhizinisi umfowethu la usandile ukukhuluma ngendaba yabadansi ngiyacabanga ukuthi uma ubheka kahle umthetho osivivinya lo wesibili kakhulu uyakhuluma ngabo abadansi ngoba phela abadansi nabo sibafaka ngaphansi kwabantu abama-performers I think lo mthetho lo ukhuluma nge-Performers Protection Amendment Bill uyakhuluma ngabadansi ngoba nabo abantu abaperformayo so as a result nabo they form part and parcel of abantu abavikelekile amalungelo abo ngaphansi kwale mthetho emibili waphinde wakhuluma ngendaba yegwaragwara gwaragwara dance ukuthi ivikelekile yini ngaphansi kwalo mthetho izovikeleka uma umuntu owaqala ukuthi ewudanse lo mdanso kwenza isiqiniseko sokuthi njengoba uyena owusungulile ukuze phela into uyivikele uSibisi uzongivumela kufanele uqale ukuthi uyiregister leyo nto kufanele uqale uyiregister kwi-Companies and Intellectual Property Commission ukuthi ukuze uthole umnikazi ukuthi lento eyakho ukuze omunye umuntu engakwazi ukuthi ayisebenzise engakwazi ukuthi wena ekukhokhele uma mhlambe wakwazi ukuthi ayiregister uzoba namo wonke amalungelo uzoba ne-exclusive right njengoba eshilo umfowethu ukube lo muntu wakwazi ukuthi lo mdansi awuregister but umthetho uyabavikela labo bantu ngicabanga ukuthi izona-ke lezi zinto iy'ncomo siyasithatha isincomo sikaNosipho ngempela lezi iy'thangami zibalulekile ngoba ziyafundisa njengoba ngisho nje nami kuningi esengikutholile ngokuhamba lezi ndawo ngoba ngiqalike mina namhlanje noma nakuba ama-public hearing eqali namhlanje kodwa ngeke ngahlangana ne-creative industry namanye amalungu e-creative industry nami ngathola ulwazi kahle ngaphinde nami ngavakashela nezinye iy'khungo ngathola ulwazi ukuthi izinto zenzeka kanjani ngicabanga ukuthi-ke siyasithatha-ke isincomo sakho nisiphakamisa ukuthi nabo laba basemakhaya ey'ndaweni emakhaya kuzofanele ukuthi sifike nakubona. Kodwa ngithi-ke angingabi thina kuphela lesikhuluma nje nozakwethu la etafuleni ukuthi ngicabanga ukuthi i-CIPC okuyi-Companies and Intellectual Property Commission kufanele yenza ama-roadshow ifundise abantu ukuthi ukuze ilungelo lakho livikeleke uregister kanjani ngoba iyona ndawo la ekhona eregistrwa khona ukuze ukwazi ukuthi uvikele ilungelo lakho. Sithola ukuthi ise Gauteng kuphela le ayikho kwamanye ama-province futhi ayihambeli kwezinye indawo. Abanye abantu abanalo ulwazi ngemisebenzi abayenzayo. So siyogqugquzela-ke nathi senze iphakamiso ukuthi inhlangano enjengalezi ayihambele la kukhona khona abantu ukuze abantu bebe nolwazi. Ngoba uma unolwazi ngicabanga ukuthi usuke ukwazi ukuthi ube empowered ukuze ukwazi ukwenza iy'nqumo ey'fanelekile. Kafishane nje yilokho ongivumelana nomfowethu uMsomi uNomdayi ukuthi ngempela nathi bese ngihlanganile nabafowethu abasuka kwi-creative industry kulela cala laseThekwini la besihlangane khona kwaba ukuthi siyavumelana no-Chief Whip uMkhatshwa ukuthi uzokhulumisana nosihlalo ukuthi sibe ne-workshop ngaphambi kokuthi siqhubeke ngomhla ka-31. Kufanele ukuthi sibe ne-workshop ezokwazi ukuthi sifundisane kahle, sihlomisane kahle, sinikane kahle ne-information ngoba i-information ngale mithetho emibili ayiqhamuki kuphela ngakuthini but into engiyibonile iqhamuka nangakuningi ngoba abanye bethu basanda ukungena kule ndima le intellectual property. Umuntu wayeyigcine lento eyifunde esikoleni as a course kodwa bengakaze ebe kwi-practice. Now mase unika umthetho ukuthi deala naye nawe uyihlomise ngazo zonke indlela uthola ulwazi kubantu futhi abaziyo ukuze nawe uma usululeka amalunga noma usuwenza i-report uwenze i-report e-inform even though ungakaze wena upractice ngaphansi kwalomthetho. Kubalekile ukuthi-ke sisaxoxisana nehhovisi between usihlalo baxoxisana no-Chief Whip ukuthi before siye eMkhumbane eThekwini umhla 31 kufanele kube khona i-workshop ezoba khona ngoba into esibukile ukuthi kuhle ukuhlangana nawo wonke umuntu kodwa into esibheke kakhulu ukuthi siyafuna ukuthi sihlangane namaciko nakuyi abantu aba-directly involved nakuyabantu njengomfethu ade egcizelele ukuthi kuyo yonke into esiyenzayo ngale mithetho emibili funa sicabangele amaciko ase-South Africa. So ingakho sibone kubalulekile ukuthi funa sibe ne-workshop nawo amaciko sizwe kahle eduze iy'khalo zabo nawo ukuthi bona kulo mthetho ngoba phela asikwazi ukuthi sithi asiwufuni lezi nguquko kodwa kufuna sibuke ukuthi hayi lokhu siyakuthatha. Asikwazi ukuthi everything asiyifuni ngoba kubalulekile ukuthi kube khona inguquko. Asikwazi ukuhlala nomthetho owashawa kusewubandlululo sesiphila kwesinye isimo. Kubalulekile ukuthi lokho esikuvumayo mhlawumbe sihambise khona ukuthi nakho esithi akushintshwe siyakuvumelana konke akube kuqala kube kusebenza while sisahamba siyo-researcha indaba ye-fair use ukuthi ngempela ngabe siyayidinga yini noma cha. So kubalulekile-ke lokho. Kafishane nje mfethu ilokho engingakusho sihlalo kambe nginika okuzakwethu uma kukhona okukhona ethi ukuphefumula uMahlenga usuka if mhlambe kukhona nawe ufuna ukuphefumula okuncane ungangena sengisho ukuthi engalula angimkaleli angalula kodwa-ke ngizonika yena ithuba naye njengoba debhala la kodwa ngiyacabanga ukuthi ezinye zezinto ey'phakanyisiwe la ukuthi kufuna ukuthi siyibheke siyayithatha-ke siyayibheka kodwa siyacela ukuthi abafowethu sithole imininingwane yabo njengobaba uNhlanhla Sibisi nabafowethu la sicela ukuthola imininingwane ukuze bese senza nale workshop i-workshop iba productive, ibe fruitful, ibe beneficiary if isitanda abantu abanolwazi. Ngoba ngeke sihlangane sonke sinolwazi olulinganayo. Sifune nabantu asebethe ukuthi xaxa bezokwazi ukuthi nabo bebe nama-views abawenzayo. Sizocela ukuthi mesihlukana la besala abafowethu sithole imininingwane ukuze sixhumane nabo. Ngiyabonga mina ngokula side.
Sibonge. Ngicela nje ukuba ngithuba sixoxe le ndaba ngoba ikutshela izinkulu iy'nselelo. If besiyiplane bekuzomele sithole nozakwethu baka-Arts and Culture. Manje inkinga besizokhuluma nje ngomthetho thina nje. Kanti yabona okuningi kwakugamanxa kudlulele ngale. Suthathile umbono ukuthi kumele sibe nasinye isigaba la sobuya nabo sizoxoxisana ngey'nselelo ey'khona within i-creative sector nokuthi silekelelana kanjani kuzona nokuthi yiphi iminyango ekhona ukulekelela ngoba miningi iminyango ekumele ilekelele within this sector. Yabo kade ngibona nje recently uzwelonke u-advertise i-National Arts Council ukuthi phinde yawavula futhi amathuba ukuthi ni-aplaye for i-funding ngekahlamezeka kokuvala kwezwe. So umnyango ka-Arts and Culture, so miningi imikhakha ekhona but ekumele mhlawumbe ngelanga siyithole nayo size nayo sexoxe because ezinye zey'nselelo ezinye ngeke saba ney'mpendulo zazo sila etafuleni ngokwethu. Okwanamhlanje I think siqedile bakwethu. Siqoqele le mbiko uma khona abangibhala abanye nansi i-email laphaya ekadimba ubhala uma ufuna ukubhala i-email wenza ama-submissions kulento esikhulumela kuyona ngale mbono eminye niyibekile la ukuthi umthetho uma sulungise kanjani. Usazoba ney'khawu ezinye ehambayo isifundazwe nje. Sizoya eThekwini, sizoya eZululand, sizohamba about 5 ama-districts kwi-province because ngeke sikwazi ukuhamba ewonke ngoba maningi kakhulu. So sicela ukubonga egameni lekomiti lokushaya kwesifundazwe lokuthisa zomnotho nezokuvakasha nokusibeza lekushaya lesikhathi sixole nje kubantu abadala ukuthi sigcine sinipha amanzi kuphela ngoba bese konakele kodwa likhona ihamba idlana uma siqede ngikuthweswa ngingena kuloya mnyango loya ngizothola khona okokwehlisa nibamba umoya noma uthi uyekhaya uphuza amaphilisi kashukela kube sekungconywana. Bonke kakhulu bakwethu.